We're going to be looking and building on this idea of the role of law in corporate purpose in this session. And a few of you have talked about a wonderful students, young scholars yesterday who presented papers. And I came in the middle of the afternoon session, and just as I was coming in the door, someone asked Colin the following question. They said, can law and regulation achieve the goals that you want in corporate purpose? And as I walked in the door, Colin said, in answer to that question, absolutely not, but law and regulation can stand in the way. And I thought, that's throwing down the gauntlet, Colin. To say that as a lawyer walks in the room, you know, the only role for law is an absolute spoiler. I thought it was a gutsy move, Colin. So we're going to try in this session to show, you know, we can do something to help in this regard. We're going to cover a lot of ground. I want to have time for questions at the end of it, so please, you know, write down your questions as we're going through. And we're just going to throw it open and just get moving right away. And so at a conference recently, someone asked another question, which is, or was, is corporate purpose just a fad? Is this something new and bright and shiny and that it's all going to be gone very shortly? And so I wanted, first of all, just to turn to you, Elizabeth, and say, you know, in law, is purpose just a fad? Is it going away? Has it been there before? So over to you, Elizabeth.
Thank you so much. Well, it's noticeable, I think, that we have different ways of talking about corporate purpose across different conversations. In law, corporate purpose is one of the oldest concepts because as long as we've had corporations, we've had the concept of purpose. And part of that is because when you create a corporation, you create a separate legal personality and you need some coordinating mechanism stated for what that will do. And especially as corporations can have existence beyond that of the humans tied to it and they can shift over time, purpose has served as a coordinating mechanism for that. And it goes back to the earliest charters that we have still documents for. You can see the kernel of a purpose clause even in, you know, monasteries from hundreds of years ago. So we have a long history of corporate purpose clauses in corporations referring to what the corporation is chartered for. And then I'll just say one more brief thing about this. So corporate purpose is very old in the legal context. And on top of that, we have a couple different ways of talking about it today that are also pretty old, not nearly as old as the corporate purpose clause itself, but some would say it's related to that corporate purpose clause in that each corporation has a purpose. And we've heard that theme today as well about the kind of unique ability of a corporation to choose its own purpose. That you see in the law as well. A reflection of that is in the corporate purpose clause, but we talk about it in corporate law that it's enabling of choosing the purpose of the corporation. The business organizers have a lot of ability to do that. At the same time, there's a very old debate that goes back more than 100 years about, in the broader abstract sense, what's the role of corporations in society? What is their purpose? And that is a different debate that largely has implications for fiduciary law, shareholder value maximization, those sorts of conversations.
So that's at a meta level as opposed to individual company. And so I want to ask now, like in Denmark, Christina, can you tell us how this plays out in constitutions of companies in Denmark? What do you see as, she's a real practicing lawyer, not like the rest of us who are academics. Christina, over to you.
Thanks, yeah. So the practical viewpoint here is, I think really, when discussing corporate purpose from a Danish legal point of view, you can look at it from two angles. So firstly, I think we do see a lot of commercial foundations as Carlsberg that was discussed earlier. These are usually foundations that have been set up by founders of successful industrial companies that have set up the foundations to sort of ensure perpetuity of the company that they have so successfully created. And all of these foundations, they have a fairly broad purpose and very developed purpose set out in their foundation papers. And since these foundations are characterized by not having any owners, it's really the foundation or the purpose that drives what they can do. And that purpose is always twofold. There's a commercial purpose and a more social or even philanthropic purpose, so use private money for public good. And I think that institution is very widely used and seen and recognized in Denmark. The other aspect of legal purpose is looking at how it's used in sort of corporates, the limited liability company and so on. And there, the Danish corporate code requires, as you pointed out also, that really there is a purpose set out in the Articles of Association or bylaws of Danish companies. And so in the one sense, you could think that that would then restrict what companies can do, and obviously it does in some sense, because all purposes of Danish companies will set this out in some specificity. However, all Danish companies have been a little bit creative and have said that other than the very specific purpose, they can also do whatever the board thinks right at any point in time. And that obviously creates a lot of flexibility and also creates a space for companies to develop over time, not steering far away from the specific purpose in their Articles of Association, but allowing it to develop with time. For instance, also taking into account obviously ESG and other social topics that are now a very important part of the public sphere.
Yeah, Michal.
I think maybe another way to understand your question is, has something changed? And I think, we think that something has changed, that incentives have changed. And the reason incentives have changed is because there is an increasing demand for ESG, or for at least part of it, especially for diversity and climate activism. And this demand, the way it manifested itself for different reasons, created strong incentives, not always optimal, sometimes skewed, but strong incentives for CEOs, for the index fund managers to respond to these demands, to get flow, to protect themselves and so forth. So I think that something has changed, and it's a good opportunity to start to look at these incentives and to look how exactly it pushes the buttons of this.
And I want to come back to you on the point of incentives. But one thing I want to, Colin talked about at the beginning, that this is very contentious. Professor Ed Rock has talked about how different disciplines are almost like in a Seinfeld episode. They're all talking about different things and they're not really coming together. And I think in law, corporate purpose has been particularly contentious. And I wonder why. Is it because we have this old Latin doctrine, ultra vires, which really plays into what Christina was talking about, where corporations had to place a purpose in their constitution, but that was a way of government restricting corporations in what they could do. It was certainly not a mechanism for government saying, go out and help us save the planet. And so I think, for some lawyers, such as perhaps Paul Davies, this idea of bringing back corporate purpose was, well, we took a long time to get rid of those restrictions. So do you agree with that, or do you think something else is driving why it's been so contentious in law? Elizabeth?
Yeah, I guess that's why I think it's helpful to think about there being corporate purpose at the individual firm level and a debate about corporate purpose on the society level, because then you can start to make sense of what you're hearing when people talk about it in these different ways. Because I think at the individual level, there has been a revival of thought, especially with the creation, for example, of benefit corporations to allow for a dual purpose in firms, et cetera. But mostly, I think the history shows that there's a real tension and difficulty in creating some kind of actionable, meaningful statement of corporate purpose in a charter that can be an actual enforcement mechanism, but not constraining the corporation too much and having the flexibility that many would want the corporation to have, even at the individual level. And so there's been just years in history across many different countries trying to figure that out with the ultra vires doctrine, with other mechanisms. So that one I think is not so controversial. It's really when we talk about it at the societal level where the debate is happening. And that is, of course, not surprising that it would be controversial, because really that's about everything else in society that gets debated. And the role of corporations as very important economic and social actors, of course, would be one of the hottest topics.
Yeah. But in some ways, it goes to a very narrow technical point that I think came up in the last session, which is who gets to decide about corporate purpose. Now, at a really narrow point, Christina, you know, where is this purpose going to be? It's going to be in the Constitution, right? And who gets control of the Constitution?
The shareholders, the owners, yeah.
So, you know, in some jurisdictions, such as Delaware, you cannot alter the Constitution without the board agreeing to it going to a vote. But in other jurisdictions, such as England and Australia, my jurisdiction, shareholders can initiate alterations to the Constitution without the board. So, you know, at a very technical level, who gets to decide may differ, and it may differ where you want to have the corporate purpose, because if it's too difficult to alter the Constitution, you may want to think of alternative places where you can have it, where you don't need to have the shareholders, often with a 75% vote, to get it in place. So that's a very minutiae technical issue, but it really goes to that point of who gets to decide. Anything more on this point? Let's move on then. So I want to talk about something that bubbled up in a lot of the earlier sessions, I think, and that is how does corporate purpose intersect with a range of other concepts and topics that are out there in this new societal zeitgeist that we're seeing? And I'm thinking of ESG, which has been talked about, corporate culture, trust and reputation. Is purpose the organising principle for all those things that are in the corporate governance zeitgeist today, or is it different? And I don't know the answer to that, so I'm hoping you can help me out. Who wants to jump in? Christina and then Michal.
Okay, but I think actually it can all be captured by the purpose, the corporate purpose, because as I alluded to before, I really see the corporate purpose, at least from where I am in Denmark, as really an umbrella from which the board, the company can act. And so really, yes, I do see that it all fits within the purpose.
Yeah, Michal, you want to say something?
You know, I think that if we're looking at what's happening now, and that's also is related to your question, who is going to decide? I think that, you know, because I view it as something that is driven by demand, by increasing demand, I think that corporate purpose is really defined currently by this demand, and people feel frustrated that we don't have a good definition for ESG, but it's not in our hands. It's coming from grounds, and the diversity and climate appeared on top of all the surveys of investors, and especially young investors in the recent years. So, and that's also for who decide. I think it's even if we have it the law or have it in the company documents, it's really respond to an outside pressure.
And it's something deeper. And, you know, I thought in the first session, Claudine, when she was talking about purpose and saying, well, we don't trust what's in, you know, written down in the Constitution, we don't trust what the CEO says, we want to go down into the belly of the organisation and see what employees think. To me, that spoke much more of corporate culture to me, and that seemed as if they were being used in a very similar way. Elizabeth?
Yeah, I guess I would just add that I see it differently. I don't necessarily see it as corporate purpose as an umbrella and somehow it connects to everything. I hear people say that, and then I wonder what that really means. I see corporate purpose more at the individual firm level happening, where if there is some kind of guiding set of principles, whether that's in the corporate charter or not, that seems to be the way that often it's discussed in the business context. I think in the corporate charter, from a US perspective, we rarely expect to see that. Most businesses take advantage of the flexibility and say that it's for any lawful business activity, so that's not the place that you find it. Other corporations might create mission statements and other things that are really managerial tools for creating a vision or strategy that may serve a very useful function at keeping a company moving towards certain values. I think companies also use those words a lot too, about creating corporate values, et cetera. But I think corporate purpose doesn't necessarily connect to all of these other concepts that we heard today in such a straightforward fashion. ESG has a different history and has some different meanings. Sustainability has some different meanings. So I don't see it as I am a researcher of these various concepts. They have different histories and meanings to me.
It is interesting that both in Denmark and in Delaware, there is still a requirement to state a purpose in the Constitution, but of course companies have expanded it so that it's anything we think's a good idea at any moment in time. We got rid of it completely. So in Australia, you don't have to state a corporate purpose in your Constitution. Recent studies that have interviewed company directors and managers about purpose and culture have found that corporate managers do seem to equate corporate purpose with ESG, and they immediately jump into talking about what their company is doing with ESG. And Elizabeth, you just talked about, ESG has got this, quite specialised legal history. And so I just want to throw it to you. 20 years ago, everybody talked about CSR and it did not get much traction, corporate social responsibility. But now ESG, environment, social and governance, is absolutely embedded. It has, to quote Alex Edmond, gone mainstream. Can you give us a brief snapshot of how that occurred in law?
Sure. Well, it really arose out of the business community and in collaboration with the United Nations. So there had been a long history of the term corporate responsibility going back to the mid-20th century, and it wasn't tied to corporate value or pursuit of corporate value. It was an understanding around the responsibilities of business persons operating in the community, et cetera. But then towards the later part of the 20th century, there were a lot of efforts to try to make the business case for corporate responsibility. And ultimately, with that as being kind of the background conversation, the United Nations in the late 90s, early 2000s started to move towards a collaborative stance towards the international business community and started something after the Global Compact called the Who Cares Wins initiative. And out of that came the term ESG in 2004. And it was really the United Nations collaborating with big players in the financial industry. And the first usage of that term was around a concept about factors for analysis in pursuit of some kind of risk-adjusted long-term shareholder value with a more capacious understanding of what would be material. And then since that time, in the last 20 years, we've seen a lot of different usages of the term ESG. But you can see just from thinking about this, corporate purpose, very old concept and even has a legal basis, and it goes right to the idea of a legal personality of the corporation. By the mid-20th century, with the rise of large corporations and a lot of concern around societies with these large corporate social responsibility, and then by the early 2000s, with large players in the financial industry, after some corporate governance scandals of, Enron, et cetera, in the early 2000s, more concern around using environmental, social governance issues and factors around the world in different ways for analysis. First, it was for investing, and that really came out of a different set of actors.
And what I think is quite interesting is we tend to think of corporate law as being very national and, should governments around the world be putting in place these rules, to minimise damage to the environment, etc. But this initiative is transnational. It came from the UN, from, up, down. Now, so that's ESG. Corporate culture, I thought that something really interesting came out of the last session, talking about how you can have inconsistent corporate cultures in the context of M&A. And so I wanted to ask Christina, who does a lot of M&A work, do you find that? Do you find that there are companies that think they're going to have great synergistic, wherewithal coming together, where the cultures just are such a clash that they cannot fit? And is that because their purposes are different, or their cultures are different, or they're both different?
I think, yes, there are definitely a number of M&As that are not successful on that basis, as you say. I think as a rule of thumb, us that practice it says that only 50% of M&A deals are actually successful. Obviously not necessarily for purpose or cultural reasons, but definitely I do believe that a number of them really unsuccessful on the basis of cultures not being sufficiently fitted towards each other, and obviously companies not putting in enough efforts to actually merge in,
Can you give us a
good time.
concrete example, without naming names, of incompatible cultures?
Well, I saw one firm, for instance, where actually they did end up being very successful. So in that sense, it's not a good example here, right? But they actually determined to work extremely hard on it, and it took them more than a decade to reach a common culture where everybody in that group of companies felt that they belonged to the same group and were not very narrow-minded as to their own specific little turf. So just to really say that it does take a lot of effort. As I said, I'm not sure that as such it's very, very, at least corporate purpose driven, but it's more the fact that really culture means a lot.
Yeah, but it's interesting because it shows culture can change, but it takes a lot of effort to change it. Michal, can I go back to you on this point about the drivers of ESG and, where it's coming from and why there is so much pressure on companies at the moment? So I know you've done work on this.
So in our work, we look exactly at that, trying to understand how this increase in demand is incentivizing managers to act. And I think there are different ways, but I'll point out the main channels. I think first, CEOs face a lot of risk from cancel culture and boycotts. So cancel culture in an investor portfolio is really negligible. It's a small magnitude, it's partially diversifiable. But for the CEOs that are targeted, it could have significant effect on their career. There's now evidence that negative news, ESG news, are associated with higher CEO turnover and less successes in the next jobs. It's a risk, it's a personal risk that is non-diversifiable for the CEO, and they can use firms' resources to mitigate it. So I think that that's already by itself a strong source of incentives, and sometimes even maybe too strong because it's not aligned with shareholders and not necessarily aligned also with the total welfare. But it's a strong source of incentives that can explain part of why we see the rise of, or CEO's response, at least for the demand for diversity and for climate and so forth. Second, for the index funds who had kind of very little incentive to try to compete with each other because they couldn't really attract investors and so forth, the opportunity suddenly, or the risk of losing some investors that are interested in ESG stewardship and not only in fees and returns, is a big change from what we knew. You can increase your MU, or you can lose some, and it's a big risk. And that also drove them to become active to attract these investors. And that's also not optimal, because if they prioritize their assets on share value, they could also become too aggressive. And then on top of that came the activist hedge fund and enter the game and leverage on ESG. And now managers are looking inside their firms to look for ESG vulnerabilities in order not to become targets of activism. So I think the whole system operated in a way that really created new incentives. And
what I think is fascinating about your research is we tend to think, well, it's fabulous if companies are spending money on ESG, but you point out it can be done in a very self-serving way, and we need to be aware and keep an eye on when that is happening.
Right, and also it's limited because it's only on the topics that demand is focused on.
Yep.
And managers who are very powerful or have a market power like Amazon are less sensible to this, and there are other limitations as well.
And that was also a big problem with philanthropy. You know, management could pick and choose. Oh, we think that's, kind of a sexy topic to give money to, so there is this ability to choose in ways that are self-serving. One topic that has just, kind of gone around the room during our sessions so far today has been executive pay, and whether executive pay has a role in the corporate purpose debate. And it can come up in two ways. It can come up either in terms of rewarding executives for being more pro-social and wanting to, save the planet, or it can come up in a punitive way, which is how it's being used at the moment for those of you who have been following the Qantas matter in Australia, that the former CEO has just been told you're not getting a bonus and you may not be getting a lot of other money that you thought you were going to be getting when you retired. So my question is, well, I might ask Christina, do you see this being used in executive pay in Denmark? Because I think it is becoming much more common in the US and in Europe. What's happening in your country?
No, I haven't yet seen it very explicitly being mentioned, but obviously as ESG has moved up to be part of the corporate strategy, obviously also for European companies being part of the license to operate, since we all need to measure and report on it in a not too distant future. This is certainly something that now also CEOs want to deliver on and are measured on, but no, I haven't seen any specific incentives directed towards ESG initiatives.
My sense is that it still is only forming maximum of 20% of pay. So the rest of it is let rip, but then 20% will be, and please don't destroy the planet while you're letting rip. Elizabeth?
Yeah, I think we've seen in the US a strong trend towards ESG-linked compensation. It's a certain portion, and some companies have done it. And I'd make 2 points. One, clearly in a system like we have, where you have an individual firm with a corporate purpose, but they're engaged in activity in a broader system, engaged with investors, activist investors, markets, all sorts of actors on the corporation, incentives matter. So executive compensation is a good one to look at. But it doesn't seem that the world has done a great job yet of figuring out how to do ESG-linked compensation in a way that's effective at some of the goals. There's been legitimate concerns raised about the way that that's being implemented and whether that's getting at real results that people seem to be seeking by doing that.
Michal?
I think that boards who set the compensation also have incentives that the firm will take care of ESG. Boards have been voted against by the index funds for low ESG. But again, I think probably they realize they don't even need the incentive compensation for that, because managers are on the same page with them, because both face a risk of even personal risk for not cooperating with this. So I think it helps, of course, it's incentives, as Elizabeth said, but there are already strong incentives in place without any legal mechanism that adds on that.
Yes and no. I think, often it may just be thought that this is not going to be found out. And so you can be getting phenomenal results, and this is one of the things that's coming out in the Qantas matter at the moment. The Competition Authority in Australia has said that it's going to be, well, I think it started proceedings against Qantas for saying, well, you made phenomenal profits, you did it by improper means. So, I think clawback is going to become a more important issue for these sort of antisocial type mechanisms of making profits for companies.
No, I think that's completely true. I think the effectiveness of ESG is going to depend on how sophisticated the demand is and whether or not it responds. And to some extent, I think there's already a learning process. So some of the CEOs were fired because of employees reporting on Instagram after they posted that they support that goal or that goal, reporting about the toxic environment within the firm, just from within on Instagram. I think that after the murder of George Floyd, when firms started to kind of show their support on Instagram of the Black Lives Matter movement, there were blogs that were pointing out that these firms pretend to support the goal, but actually their workforce is not diverse. And other firms pretend to support the goal, and actually their political contributions are going to different places.
I want to come back to that, political contributions, sure. Absolutely. But I do want to ask you, Michal, ESG again, there would be some who said, oh, well, we already had that with US constituency statutes in the 1980s and 1990s. And some of you might remember a number of states in the US, but not Delaware, interestingly enough, passed statutory changes saying that directors could consider the interests of stakeholders. Some of those states said that the board could consider the interests of stakeholders anytime. Others said that they could consider the interests of stakeholders if they were facing a hostile takeover bid. So what's new about what's happening now compared to what was happening then?
So then they did not have the incentives that they have now. There was no demand, or if there was demand by other social movements, it didn't come into the economics life. And these particular statutes were driven by managers themselves, by lobbying by managers themselves, because they wanted to protect against hostile takeovers. So this is also why this is probably the only example that we had in the past. In the past, they had no incentives whatsoever to cater to other stakeholders, and also the corporate law states who try to attract managers had no, as a result, had no reasons to include it in the law. It was coming from the managers themselves. Having said that, I think that also today, in issues like that, they probably don't have strong incentives, because the demand for ESG, the young generation and other people who care about ESG hasn't focused on governance issues or very little on employees' rights as well, and so forth.
So back in the day with constituency statutes, they were adopted from within. Boards of directors were lobbying government to introduce these because it protected them in that era of takeovers. But now managers are being prompted from other pressure points coming from outside.
With respect to some issues, not with respect to takeovers and sales of the companies, but with respect to the current rising issues of ESG.
You mentioned lobbying, and I want to go back to you on that. So that's another market development that is affecting shareholder activism in the US particularly, although Christina may tell us that it's happening in Europe as well. This growing pressure on companies to disclose their contributions to lobbyists and politicians. And I understand that that was something that was involved with the well-known ExxonMobil activism campaign. And I just wonder if you could fill us in on how it played out there.
Right. So I think that, we used to say it's probably better to leave these environmental issues to environmental regulation, or labor issues to labor regulations. And there's a lot of truth to it, but we didn't see a lot of this happening. And part of why in the US a lot of this did not happen was that firms dedicated a lot of money to fight this type of regulations through political contributions and through lobbyists. And the lobbyist money didn't have to be disclosed. So in the fight of Engine One with ExxonMobil, the index funds that eventually supported the Engine One candidates to the board explicitly explained that one of the reasons they decided to support Engine One candidates was that Exxon was not transparent on its lobbying money, what it did with its lobbying money, which was a high budget. We're talking about a lot of money. And especially it was not transparent about whether it was consistent with their public support of the Paris Agreement. And Exxon basically gave a lot of money against these environmental regulations and didn't want to disclose that. Eventually they disclosed some of that. But now there are also a lot of shareholder proposals demanding firms to disclose their lobbying contributions, and I don't think we have a way to measure it, but
So it didn't work out well for Exxon, because it did drive the institutional investors to throw in their lot with Engine Number One, the hedge fund. Now, we're not going to have time to talk about two anti-ESG, anti-corporate purpose developments that are going on, particularly in the US, but let me just flag them. One is, backlash. One is having anti-ESG in your heart rather than having, corporate purpose and ESG in your heart. You know, Republican states have anti-ESG in their hearts, and that is affecting what shareholders can do. And that affects theories like Hart and Zingala's, who want to leave it to shareholders. You know, because we see it's contingent. It can change in a moment if you get government pressure against that. The other thing that's interesting, which Elizabeth and Michal told me when we were chatting about this earlier, is that US constitutions are sometimes providing a blockade for ESG developments. And so in California, there was a statute that required publicly listed companies to have, quote, women and underrepresented communities on their boards of directors. And that was just recently struck down by the courts as being unconstitutional under California's Equal Protection Clause. So once again, developments in the market that are, you know, potentially stymied by other, well, that's a regulatory development that's potentially stymied. So before we go over to question time with our audience, I want to really talk about where the rubber hits the road in terms of what I think law can bring to the table in this area. And that is something that everybody's talked about in the session so far. Should we be skeptical? Should we be cynical about companies who say, oh, you know, this is our purpose and we're going to save the planet, and then don't walk the walk? So organisational hypocrisy, purpose washing, greenwashing. What can law and legal doctrines deliver to stop that and to call it out when it occurs so that, you know, companies cannot be engaging in organisational hypocrisy? And, you know, like, what would be your top 3 hits of what you'd be thinking in terms of legal doctrines? And I'll tell you what I think my top ones are. Anyone?
Yeah, well, I think at least from a practical point of view, I think in this country, what you would see other than media, the Instagram, publications and so on, I think really is that the shareholders, and in particular the institutionals, would just move to actually make sure that that board and that management is changed. And that's fairly easy to do, since it doesn't take a lot usually of bigger shareholders to just agree on
roll
that.
the
really.
board.
Yeah.
Yeah. And that's also a much bigger risk now in the United States because of de-staggering of boards at the pressure from institutional investors over the last few years. So that protected boards of directors, but that protection has now gone for many companies in the US. You can correct me if I'm wrong on that, Elizabeth.
Sure, that's right. I was thinking of some other things
Yeah.
as well. So we already have legal tools for these sorts of things, and people are starting to use them, and companies are starting to pay a lot more attention. I've been in a number of conversations over the last couple of years with people that sit on boards and executives of large companies that are saying that their lawyers are telling them, for example, that they need to pay a lot more attention to things like, for example, not only what they put in their securities filings with the SEC in the US, but, oh, you say you have this sustainability report or something you put on your website, you thought people didn't pay attention to those and those have no legal consequence. Well, actually, those are statements as well from the company. And if you're saying inaccurate things, that can also lead to the same sort of liability. So get a handle on all of the sorts of statements that the company makes across different spaces and pay attention to whether they're accurate or if they're greenwashing, because there's enforcement actions from regulators, there's securities fraud class actions, and a number of other very well-established tools for going after companies that do that.
And is that mainly at the federal level, like SEC actions, or state level, or both?
Well, the SEC is at the federal level,
Yeah.
but securities fraud class actions are private actions. Yeah.
Michal?
I think also disclosure, which is already happening to some extent, but it will help demand to do its job more effectively. Again, it will still be limited. It's not that, yeah.
Well, ones that I think are interesting, shareholder inspection rights, which were a very low-level issue in corporate governance, have recently come to the surface. Randall Thomas has a co-authored book on shareholder inspection rights around the world, and when I was doing a project with my colleague Tim Bowley in relation to that, we had assumed that shareholders could only ask for inspection of company documents when we started the project in relation to things like fraud or, mismanagement and things that affected their hip pocket. In 2021, that changed in Australia. There was a case called Guy Abrahams against the Commonwealth Bank of Australia, where a shareholder was able to get internal documents of the company because he said that, of the bank, I should say, that the bank had been making statements about not financing significant oil and gas projects, and he said that's inconsistent with what's really going on. I want to see the documents. So if it is possible to get access to internal company documents relating to organisational hypocrisy, you've got a lot of wherewithal for individual actions, class actions, etc. So that's one thing that I think's a space to watch. The other one that's a very big issue in Australia, but perhaps less in other parts of the world, but I think maybe changing in other parts of the world, is breach of directors' fiduciary duties in relation to climate change mitigation. And I think most company directors in Australia just thought, yep, our duty is to make a lot of money and that's all kind of out there somewhere. And then in 2015, a very old colleague of mine who was at law school with me, now a very senior barrister in Australia, he wrote an opinion piece where he said, directors in Australia that do not take account of the dangers of climate change when they are in industries where that is relevant to their financial aspects, they are absolutely fair and square, potentially going to be in breach of their duty of care. And why that's really, it shook the director world in Australia, because most actions for breach of director's duty in Australia are not private actions. They are brought by the regulator, the Australian Securities and Investments Commission, or ASIC. And ASIC has brought a lot of director's duties breach of care cases and won them. And so that completely changed the whole atmosphere in boardrooms across Australia, to have a senior barrister say, no, you are seriously at risk if you are not taking into account these risks. It's always been thought, that's not going to play out in Delaware because directors have got so much protection. But I think Leo Strine has recently been saying it could play out in Delaware as well. Michal?
Right. So Leo Strine has several papers, I think, where he's arguing that it could naturally come under oversight of risk duties. And I think he's completely right about that, in the sense that firms already defined it as a risk if ESG failures, and you could make the argument that it would also hurt the firm profitability and consumers base and employees base if there are significant ESG failures, and therefore could cause harm to the company. I think the Fox defamation case even is an example of an ESG harm or stakeholderism that failure, and now the board is being sued for and that also, oversight failure. Yes.
That also brought into play shareholder inspection rights, if I remember correctly. One other thing in terms of market-based developments with institutional investor and hedge fund activism. In the US, there is the dominant paradigm is one of agency capitalism, where the assumption is you need a hedge fund like engine number one to get institutional investors off their backsides and actually, become engaged in activism. That's not what we're seeing in the rest of the world. In the rest of the world, we see a lot of collaborative actions by institutional investors, including by ACSI, which was mentioned in the last session, the Australian superannuation or pension fund umbrella organisation. And so that's been putting pressure on a number of companies, including Rio Tinto in Australia. Whistleblowing, we talked in that first session about the importance of what people in the middle of the organisation know. Well, the law can help bring that to the surface and bring that to the attention of directors by facilitating whistleblowing. So that's another way in which the law can help. Any closing comments on techniques before we pass it to question time? Let's go to our audience for questions. Yes, I don't know all of you, so if you could just say who you are and where you're from.
Thank you. Simon Whitney. I'm a lawyer. I practice law in London. Thank you very much. Excellent perspectives. As a lawyer, I certainly do believe, I think like you, that law and regulation does have a very important role to play, not just as an obstacle that we can get out of the way, but as an enabler. And one thing that I think we haven't talked about is the developing laws in Europe, in particular in Germany and France already, and probably soon across the whole of the EU, on due diligence, mitigation of harms that corporates encounter. And I was looking back at Colin's definition of purpose that he gave us first thing this morning, and to me, it sort of comes in two parts, doesn't it? It's producing profitable solutions to the problems of people and planet. Lawyers, I think, have trouble with that because it's very hard to regulate. I mean, we might have different views about whether brewing beer and making low-cost furniture is really contributing to solving the problems of the people and the planet, and we can't really legislate for that. But the second part, which is not profiting from creating problems, I think we can and do. I mean, obviously, controlling negative externalities is something that law does all the time. You can't pollute rivers, you can't put your workers in unsafe working conditions, and the Corporate Due Diligence Directive and the German Supply Chain Act and the French Law of Vigilance and various others that are appearing across Europe are, I think, generalized versions of that, giving companies responsibility for identifying the harms that they cause, not just in their own operations, but in their whole supply chain, and giving them a responsibility to take steps to mitigate those harms where they've identified them, I think is a really important potential development. I think the Commission's draft of the Due Diligence Directive has some flaws, has some problems, it's got some way to go, and it's obviously politically contentious even now, but I think those kinds of legislative interventions can be really powerful, at least in taking care of the second part, which I think is a really important part of the definition of corporate purpose.
Thank you very much. I mean, that gives great clarity to something that I've always grappled with, that, you know, how to doing good versus not doing harm.
Can I say one thing in response? I think that's such a great thing to bring into this conversation. And sometimes I think with the conversation happening in the business world and in the legal world, they don't connect so easily sometimes. But one thing that I was thinking as I was listening today to the fellow from ECGI is that when he says, you know, we're in a changing regulatory environment and we acknowledge that and we have to, you know, make some changes, that's where I hear the connection happening, where you may have companies that are working on being purpose-driven organizations and others that don't. But when you have a larger conversation around the world about where there's more consciousness around these concepts, whether or not they're precise and actionable, it could create an openness to, or at least a pushing towards companies having to move on the regulation and maybe more quickly getting into compliance or something like that. And that's where I think the connection happens, because the legal reforms could be meaningful if done well and if implemented. And the business world, if it's open to it, it can be a force against some of the issues around lobbying and other issues that we see.
And I think that's what a lot of regulators are hoping, that the companies will work with them rather than engage in cover-ups.
Thanks very much. Tom Gosling, London Business School. Very enjoyable discussion. I was interested in a couple of themes that seemed to come out from the discussion. One was that, you know, for various different corporate forms, whether it's public benefit corporations or what have you, I mean, ultimately the shareholder kind of sits at the end of it, right? Because kind of why wouldn't they, and why would you be a shareholder if you didn't? And I was also interested in response to Jennifer's last question, most of what you said was sort of traditional kind of stakeholder enforcement rights and sort of actions against companies using sort of traditional accountability methods. And I just wonder whether you do see any role, if we want companies to be more purposeful, is there any role for alternative corporate forms, or actually do they all just get washed away in the stream of the incentives that companies inevitably face? So things like public benefit corporations, are they relevant or are they a sideshow?
So I think, these are great questions, and it depends. I think the answer is it depends in which system. I think when we are asking about the law, we need to make a distinction between the US system and other systems for the simple reason that in the US, money influences law, and political contributions are not limited. And that, for decades and decades, had a lot of influence on US legislation. And so I think, and in corporate governance, we wanted to make changes for years and years. Lucian Bebchuk is here, was a huge warrior for changes in corporate governance and changing the law and changing practices and so forth and so forth. Boards were so entrenched, their turnover was so low, tenure was so high relative to other places, nothing could change that. The push from down to diversity, even though it wasn't focused on that, forced these boards to bring from outside new people. And some of them hated it, and they still had to do it. Some of them hated it so much that they paid the California fine in order not to do it. But there was pressure on them from the index fund and so forth. So I think the law, I completely agree that the law potentially has a lot of power and prospect. But only if it's optimal. And you know what? Actually, I went back to Jean Tirole initial seminal paper on corporate purpose, and even then he's saying, well, you know, some people say let's leave it for the law, but the legal process also is infused by rent extraction and so forth, so we can't necessarily count on that. So I think the answer eventually is these are all trade-offs. None of the path is optimal, and we need to take into account the particular cost and benefit of each path in each place and context and subject and so forth.
Can I say one quick thing? Yeah. So the benefit corporation model came out of the US, out of B-Lab, which were some business people who had had a sale of their company, and they felt some dissatisfaction with the way they were counseled and felt about what they understood was supposed to happen and maximizing shareholder value and so on. So they created a nonprofit, and that nonprofit came up with the basic concept for what became the benefit corporation model, and then Delaware did a different version in the public benefit corporation model. But at core, like Tom said, it was still imagined in a world where it was still ultimately oriented towards shareholders, even for an organization that had a dual purpose, profits and some other social purpose. So we only have a few thousand of them in the US, and it's an interesting development to see how much, as they originally envisioned, business could be a force for good. But it's still oriented towards shareholders, so you can see it would really matter what the shareholders want of any particular company, and that's a limited development. I think the bigger question is, can you use more imagination in the world to get beyond that model? And could you do that in a way that would fit into a world that is very much oriented already in that direction? And that's the hard questions, I think.
I know when B Corp came to Australia early on, after the new form had been introduced into the US, and they said you have to have this in Australia, the business community hated the idea, and they said no, that just isolates and quarantines good behaviour in this small group of companies. We want to transform the whole of the business community. Well, whether or not they really did, I don't know. Yes, we've got a question up here.
Thank you very much for a wonderful discussion and panel. I'm Rui Diaz from the Portuguese Corporate Governance Institute. My question draws on something that Jennifer mentioned on the fact that jurisdictions may differ on who ultimately defines what the corporate purpose is, either the board or the shareholders. So do you believe that there are, in your jurisdictions, or there should be differences in terms of the binding character of the purpose or the legal consequences of a deviation from the purpose, depending upon this difference?
You've brought us all to silence.
Which difference? I couldn't hear you well.
I mean, depending on whether it is the board that defines the purpose or the shareholders define it as it would be in my jurisdiction, and I think in most European continental jurisdictions, the shareholders have the full power to determine it. If the managers, the board deviates from this purpose, is the legal consequence different depending on who defined it?
I can answer that in relation to Australia. So in Australia, shareholders get to vote on changes to the Constitution. I would have said 10 years ago that that vote would only take place if the board wanted it to take place. I'm not sure about that now. I think there are enough activist shareholders that it's perfectly possible that a resolution to alter the constitution could come from shareholders. Particularly given, it's not hard for shareholders to put up resolutions at the annual shareholder meeting. Now, if it got 75% of votes, of those present and voting either in person or by proxy, and you changed the constitution, then under Australian law, that is a contract between the company and the shareholders between each other. But it wouldn't necessarily have immediate consequences. You could have, say, an oppression action brought to say, this board of directors is constantly deviating from what we, the shareholders, agreed would be the corporate purpose. If the company is putting out public notifications, you can then potentially have breaches of the corporation's legislation for misleading and deceptive conduct. So it could play out in different ways in my jurisdiction.
Yeah, in the US, I think the way you asked the question isn't how I would typically think about it. From a US corporate law, like Delaware corporate law, you wouldn't typically think, do the shareholders or the board determine the corporate purpose? But what I might think about is, once the company, through the mechanisms of corporate law and governance, have some kind of purpose, how sticky can it be over time? And that's a question that gets discussed in all sorts of debates about things like dual-class stock structures, benefit corporations, takeovers, activism, et cetera. And that just shows you that even companies that may start, say a startup that has some social purpose as well as for-profit nature, may have a difficult time over time staying consistent to that mission, especially in the face of many possible headwinds to that and abilities of change over time. That may be a good thing for some organizations, but it's just the nature of the system in a sense, where we have a set of corporate law and governance rules. People can use them in different ways, participants in the corporation, and it may be very hard unless you have somebody that has control of the company in a way that, it's like, if you think about, say, Meta and Mark Zuckerberg, there's a situation where you go public with a dual-class stock structure, and then you see it's pretty sticky to what he may want to do with the company. But in other instances, you can see even a benefit corporation can convert out of a benefit corporation form, and shareholders could push for that, et cetera. So it's a dynamic process, really, of purpose getting created and recreated over time.
We have another question over here. Yep.
Thank you. Klaus Ilmonen, I'm a professor of practice at Copenhagen Business School and also a lawyer in private practice. So I was quite concerned about your first reference to Collins Meyer's statement that the law will be in the way here. But I agree that the climate litigation is one tool that law provides that we've seen, and then the reporting that Michal, the new reporting requirements that will come from the EU, I think are a good example. But there was one more controversial initiative that was shot down by pretty much the whole legal community, I think including some scholars in this room, which was the EU Sustainability Due Diligence Initiative, which I think was a very controversial but interesting effort, which would really change how what the company really looks like. And I would maybe have expected a little bit more sort of constructive engagement. But even, all the leading scholars from the US basically got involved in the EU regulatory processes. So I don't know if you have some observations about that, but I just want to try to prove Colin wrong that we can do the right thing.
Colin, yeah.
Okay, just to be clear on this point, what I was saying in response to was a question on whether or not law on its own was adequate, to which my response was no, it's very much a matter of culture as well. But I do want to just pick up on this point about the distinction between law in relation to the positive element of purpose and the negative, which I think is absolutely right, and that's precisely the way in which I think about it. What I'd like the panel just briefly to give their views on is what's the role of corporate law in this regard in terms of holding directors responsible in terms of their duties to avoid profiting from detriment, because there's been a lot of discussion in relation to enlightened shareholder principles in British company law, by which directors are supposed to have regard to the interests of their employees, their suppliers, etc. But that is not interpreted in terms of them having a duty to ensure that they do not inflict detriment. So I very much welcome the panel's view as to whether or not that is an appropriate interpretation.
Yes, so I think that because the main tool is the derivative lawsuit to enforce fiduciary duties on director, which is claiming a harm, which is based on a claim to the harm of a harm to the firm itself, then probably Delaware judges are still limited to some extent with this definition of harm to the firm itself. However, I think that today the argument that there is a harm to the firm itself from causing a harm to the environment, from having a toxic culture, from lying to allow your TV interviewer to lie to the public. From all of these externalities of harm to third party, I think it will be easier to argue today that this is also causes a harm to a firm. And because of this, you know, also ESG failures are considered risks to the firm itself, right? So I think it will still hinge on whether there is a harm to the firm, and this is why I'm submitting a derivative lawsuit, because I'm doing it in the name of the firm, but it will be much easier to argue that this causes harm to the firm. Of course, you know, if there are some lawsuits that require the firm to pay some fines and so forth, which we are seeing more.
I think it really stems from legal obligations under US fiduciary law is the clearest way to have accountability. And so we need legal obligations for there to be clarity around things. So for example, if some people think doing something is wrong, but there is no legal prohibition against it, it's hard to use fiduciary law to enforce that. But where there is a legal obligation, that's where we see the rising trend, for example, of oversight duty litigation under what's known as the Caremark Doctrine in Delaware, and where that has particularly had some change in the trend is where you have very egregious situations of often involving loss of human life, and there was a legal obligation that was being violated. And it's in those situations where the plaintiffs can make a clear argument that there was a breach of the fiduciary duty of good faith and loyalty. But the legal obligation is often the key point of the argument in making out the fiduciary claim.
So in Australia, I think Australia is further along the continuum in that regard. We have got cases, and as I said, you know, most of our breach of duty of care cases are brought by the regulator, ASIC, and we've got cases that have said if the directors, by, you know, failure of oversight, you know, visit detriment to the company's reputation, that can be enough. And that's powerful. That is very, very powerful. And we've got a range of directors that are currently being sued in Australia, you know, from casinos, from various places. So it's a real space to watch, and I think there's much more potential for liability in Australia than there is in Delaware. You know, Delaware is edging towards it by, you know, but it's got to be in the duty of loyalty, because the duty of care just doesn't fly in America, but it does fly in Australia.
And I think, I'll add just a small thing that I think as a comparison, the index funds activism to vote against directors based on lack of diversity or climate probably had more disciplinary effect for the directors themselves, for the reasons that Elizabeth mentioned, that it's not only a harm to the firm, but also you need to have a breach of law. Then probably it's more effective than the law in terms of disciplining directors.
So just to put it on the record, I've argued that far from being irrelevant, that I think law should be central to the whole.
Good, Colin. Thank you. You threw down the gauntlet. We took it up. It's all good. Thank you, everyone. I think we've got afternoon tea now and we can talk more.